So I'm going to briefly introduce the speakers, and I'll let, so Jason's going to speak for I don't know, 20-25 minutes. He's suffering from laryngitis, so he might be a little bit more brief, and then Jamie and Bryce are going to comment. So Jason is an associate professor at Melbourne Law School, and this book, Damages in Human Rights, grew out of his PhD thesis at the University of Cambridge, which won the York Prize. And it's been a while in the making, and you see it's taken on substantial proportions during Jason's time as a junior research fellow at Cambridge and subsequently at the University of New South Wales. He's also got an ongoing relationship with Cambridge through his associations with the Centre for Public Law and Christ's College. Our commenters are James Lee, who's a senior lecturer in private law at King's College in London, and Bryce Dixon, who's professor of international and comparative law at Queen's University, Belfast. Both experts in private law and public law, and well placed to give a considered view of the arguments in Jason's new book. So Jason, do you want to take it away?
Well, thanks very much for that introduction, Paul, and it's nice to be here in Montreal for this because it's one of my favourite cities, but also 2 years ago I presented on parts of the book here in this faculty, so it's nice to return with a final product at the end. So what I might do is first give a general introduction to the background to the book and the state of the law of human rights damages. Then I'll say something about the tort-based approach, which is the approach I favour for assessment of human rights damages. And then I'll speak about the public-private division and the influence that has had on the development of the human rights damages remedy. And then if my voice lasts, I'll offer some remarks on alternative approaches to assessment of human rights damages, and particularly the interest balancing approach, which has been influential in Canada and New Zealand in particular. So, as I said, the book addresses the topic of damages claims for breaches of rights in charters of rights, and it focuses on English law, but it also draws heavily on comparative material and the jurisprudence of international courts as well. As the book makes clear from the outset, the field is a fraught one, and the courts across common law jurisdictions have struggled and largely failed to articulate a coherent, rational, and worked out law of human rights damages, while the theoretical foundations of the remedy remain obscure, with the general result that damages are marginalised as a remedy for breaches of human rights, and the field is in general characterised by a sea of open-ended judicial discretion, with only specks of principle barely visible on the horizon. There are several reasons for why the jurisprudence is in this state across common law jurisdictions. The first is that the field is one characterised by a difficult clash of concerns. On the one hand, these are fundamental rights, and one would expect strong remedies to follow. But on the other hand, there are understandable concerns that regular awards against public authorities will give rise to public interest concerns, such as the depletion of public resources available to fund services and chilling effects on vigorous administrative behaviour. Secondly, another layer of complexity is added in that the remedy sits at the intersection of public, private, and at least in the UK, international law, and is not capable of neat compartmentalisation with any one of these fields. So the remedy itself is one we would traditionally associate with private law fields. On the other hand, we now find it popping up in a public law field. And scholars and courts have generally approached the remedy from the perspective of, or approached the subject as one representing a clash of conflicting paradigms. So on the one hand, you could have a public law approach, or on the other hand, you could have a private law approach. But setting up the debate in this way is, I argue in the book, unlikely to lead to a viable outcome. More likely is that the remedy is going to be caught between the two paradigms and caught in a theoretical twilight zone, and as it has been, and with the result that a coherent law of damages proves elusive. So the book seeks to move beyond this stale conflict of public and private, and to try and identify an approach which is defensible on its merits, given the core functions of human rights law and the nature of the primary obligations in human rights law. So I consider a number of different possible models, but I argue ultimately for a vindicatory approach based on the approach to damages within certain torts, such as false imprisonment, trespass, and battery. And I don't argue for this tort-based approach on the basis of abstract notions of public or private, but rather because this approach is consonant with the normative concerns that underpin human rights law, and because this approach has certain merits over other alternative approaches. So if I move first to the tort-based approach, and this is really covered in chapters 2 and 3 in the book. And in chapter 2, I set out a framework for understanding variations across the law of damages in tort. So one of the key arguments of this chapter is that there is no unitary approach to damages across tort, but rather the approach taken varies significantly from one tort to the next. And I argue that these variations are explicable by reference to the different functions which particular torts perform, and the relative importance of the interests which each tort protects. And in particular, I draw an important distinction between those torts which are constituted to protect and vindicate basic interests, such as the torts actionable per se, and those torts principally concerned with offering compensation for fault-based material harms, such as negligence. Now, for compensatory torts, such as negligence, material loss is the gist of and a prerequisite for bringing the action. And in these torts, compensation is only recoverable for material or factual harms. That is compensation for the negative psychological, physical, emotional, and economic effects consequential upon the defendant's negligence. Further, in these compensatory torts, traditionally at least, other types of damages, such as aggravated damages, exemplary damages, nominal damages, are not available, and gain-based damages, I mean to say, for negligence. And these features of the approach to damages and negligence reflect that tort's basic function, which is to operate as essentially a social mechanism for apportioning responsibility for material harms. Now, in contrast, the core function of vindicatory torts, such as trespass to land, false imprisonment, and battery, is to afford strong protection from outside interference to very basic interests in land and the person, and to vindicate the importance of those interests. Now, in line with the difference of functions between compensatory torts on the one hand and vindicatory torts on the other, we find a marked difference in the approach to damages in trespassory torts compared to compensatory torts such as negligence. So first of all, for vindicatory torts, a wide range of non-compensatory damages are available to ensure due protection of relevant interests and to reinforce that they ought to be respected. And these include nominal, exemplary, gain-based damages well, aggravated damages are routinely available and regularly awarded as well. Now, in addition to this wider range of available damages, we find a different approach to assessment of compensatory damages within these vindicatory torts. So consequential factual or material loss, such as physical or emotional harm, is recoverable, as in the compensatory torts. But in addition, for vindicatory torts, one may recover substantial damages that compensate for the wrongful interference with the protected interest in and of itself, regardless of whether the claimant suffers factual loss or not. So a wrongful interference will sound in damages regardless of whether the claimant suffers any negative consequential factual effects as a result of the wrong. Now, these types of damages for the interference in itself are assessed objectively, and that they do not vary with the peculiarities of the claimant. Rather, quantum is a function of the degree of the interference with protected interests and the relative importance of the interests interfered with. This type of damage is inherent in a wrong in itself. If you wrongfully interfere with my liberty, it follows that I suffer damage to my interests and liberty, and damages for that loss will be available as of course. And I describe this head of damage for the interference in itself as normative damage to mark it out from factual loss, and also because the law constructs this head so as to give effect to the normative concerns which underpin these vindicatory torts. So in particular, the fact that one can recover damages for the interference with the interests in themselves affords strong protection to those interests, and also it serves to reinforce the importance of those interests in and of themselves. And by vindication, that's what I term the vindicatory function. So the fact that you can get damages for the interference in itself serves to reinforce, affirm, and attest to the importance of those interests in themselves, and that they ought to be respected and maintained inviolate. His voice is barely holding up, but it's hanging on in there. So, having identified this vindicatory strand within the law of tort, I go on in chapter 3 to argue that it is this approach which ought to govern the approach to damages in human rights law. The principal argument for adopting this model in human rights law is that it gives effect to the underlying purposes of human rights law, which are similar in nature to the underlying purposes of torts actionable per se. And that is to afford strong protection to basic interests and to vindicate their importance. And I demonstrate the functional similarity between the two fields by reference to a comparison of the significant features of torts actionable per se and human rights law, and find that they have features which are more or less on all fours. So, for example, standing rules are similar across the two contexts, as are the rules of assignment. Both types of claims are actionable per se, while liability is generally strict. Defences are confined to protecting the most important interests and strictly construed, and substantive questions over whether a right is breached and whether there is a justification for the breach lie with the judiciary rather than any other institution. And these features, I argue, are indicative of the common nature of the two fields, and significant features such as actionability per se and strict liability reflect the concern to ensure strong protection of the underlying interests and a concern to maintain those interests inviolate unless there are strong justifications for interference. And to this we may add that the two fields protect many interests in common, such as liberty and corporeal integrity, or at least they protect interests in common which are similarly fundamental in nature, so that the law would take on a schizophrenic nature if a strong approach were taken to damages in the context of tort, but a relatively limp approach were taken in the context of human rights law. The law would send conflicting signals as to the importance of the interests. And lastly, and this is a not insignificant point, the law of torts can offer the very thing that courts have struggled to locate in this field, and that is a coherent and worked out set of elaborate rules and principles to govern damages, and also a body of precedent to guide assessment of quantum. So that's the tort-based approach, the vindicatory tort-based model in a highly stylized summary. Now, in response, I think the inevitable response, particularly I've found more of public lawyers than tort lawyers who tend to be more convinced by this, is that human rights law is a field of public law, and that is therefore impermissible to read across principles from the law of torts to govern damages in human rights law, which we see as quintessentially being a field of public law. And I address this argument in chapter 4 of the book. And the public law, private law division does have an extraordinary intuitive appeal and has exerted significant influence over the development of the damages remedy in human rights law across common law jurisdictions. So courts will, for example, say human rights law is a field of public law, and therefore damages in human rights law must serve public law goals, which are necessarily distinct from private law goals. The common consequences of this type of assertion are that courts draw a bright line between damages in tort and in human rights law. Human rights damages are viewed as being of secondary, if any, importance in human rights law, with courts prioritizing traditional public law remedies such as the prerogative orders and declarations. Damages are to be a remedy of last resort and are subject to an open-ended judicial discretion to deny them, even though loss may be suffered, so as to protect the public interest. And quantum will also be reduced below tort, again, to protect some of those public interests we talked about earlier, such as preservation of public funds and to guard against defensive administration. So overall, the general effect where courts invoke the idea of public law in this context is to marginalize the damages remedy and to subordinate concerns of individual justice almost completely to concerns over protecting public authorities from liability. Now, in the book, this is obviously in consonant with the tort-based approach, which I favour. So in the book, I argue that the public law-private law divide and the way the courts have used it is an unsound basis for legal decision-making in general. And I make three principal arguments. So the first is that there is, in common law systems, no concept such as the state to ground a distinctive idea of public law, while processes of privatization, contracting out, and globalization render the search for a concept of the state or a distinctive idea of publicness illusory and anachronistic. The second point is that even if we could identify a theoretical anchor for developing a distinctive idea of public law, the normative implications of invocation of that idea will be bound up in interminable disagreement, which will likely lead into disagreements over political theory and the relationship between the individual and the state. As such, the idea is likely to raise more questions than it can answer, and also, where judges use it, draw judges into politically contested waters. Now, thirdly, a core premise underlying invocations of public law to guide legal development is that public law has some sort of inherent unity. So the idea seems to be that public law is unified around a set of common ideas functions, methods, principles, and so on, and that these common ideas can then be relied upon to guide legal development across the field of public law. And the problem with this idea of unity is that it is fundamentally at odds with the nature and structure of contemporary public law, which is a pluralistic and varied field, not reducible to one set of ideas and functions, so that the result of relying on a unitary conception of public law to guide legal development is likely to be the warping of doctrine, and specifically the suppression of the distinctive nature and distinctively valuable functions performed by particular subfields. And in the book, I argue that this is the very thing that has happened in relation to human rights damages, where courts have invoked the concept of public law. So in the case of, in the English case of Anna Frieva, Lord Wolfe effectively read across the remedial approach from the common law of judicial review to the Human Rights Act context, on the premise that that approach represented the public law approach to remedies and met the needs of the distinctive goals of public law. This remedial model in common law review that was read across is one focused on declaratory relief and the prerogative orders. It's characterized by wide discretion and an overarching concern for the public interest, and damages have never been available in common law review. So the natural consequence of reading across this remedial model developed in the common law of review to human rights law is that damages are nearly completely marginalized, and the focus, the remedial focus in human rights law is on declarations and the prerogative orders, while damages should be a remedy of last resort subject to wide discretion and low in quantum. The problem with this read across is that the common law, so the read across assumes that the common law of review and human rights law should have an aligned approach to remedies because they are both fields of public law. The main problem with this is that they are fundamentally different fields of public law, which renders the read across inapt. And we can see this if we consider the nature of common law review and compare this side by side to the nature of human rights law. So common law review, review on the grounds of procedural fairness, rationality, and legality, is a secondary supervisory jurisdiction which the courts possess to ensure that public powers are exercised for the public purposes for which those powers are conferred and according to basic standards of good administration. The field is one concerned not with individual wrongs, but with public wrongs, that is, breaches of duties owed to the public at large and for the benefit of the collectivity. Now, these duties in common law review, such as legality and reasonableness, are not individualized duties. So the field is not characterized by individual wrongs. So the nature of common law review as one imbued with a public interest ethos explains the remedial focus in that field on declaratory and specific type relief and the lack of provision for damages. It also explains the presence of wide remedial discretion. So given that public interest concerns underpin the very jurisdiction to intervene in common law review, the courts are cautious in their interventions not to undermine the very public interests and the interests in good administration which they are seeking to uphold through their interventions. And damages would be out of place in this field because the nature of the wrong is not an individual wrong but a breach of a public duty. And in the common law tradition, damages are a remedy for personal setbacks suffered through breaches of individualized duties. Now, in contrast, the concerns of human rights law are the near inverse of common law review, in that the focus is not on the exercise of public power and the public good, but on protecting individual rights and interests in the face of public powers exercised for the public good. So the wrongs in human rights law are breaches of individual personal rights, as in many fields of private law, and not breaches of public duties owed to the public at large. So whereas an approach focused on declaratory and specific type relief, and which excludes or marginalized damages, is of a piece with the basic public interest concerns of common law review, that sort of a remedial model is out of place in human rights law, which has a radically different function on individual rights and interests. And this in turn illustrates a key problem with reasoning by reference to the public-private divide, and that is that it can lead to reductionism and the suppression of the distinctive functions of particular subfields of public law. So damages and charters of rights should not be conceptualized as a public law remedy, but rather they should be conceptualized as a human rights remedy, and the approach to damages should be one responsive to the concerns of human rights law. So that's the talk-based approach and the possible response that it's inapt because human rights law is a field of public law. I was going to say a few things about the interest balancing approach. How are we doing for time?
Well, it's really more up to James and Bryce. Are you straining at the leash, or do you want
to come in now, or?
Depends on how your voice is.
Yeah, it's getting a bit croaky. So I think what I'll do is note that chapters 5 to 7 consider alternative approaches, that is, approaches other than the talk-based approach I set out at the beginning, and those include the mirror approach, which is the prevailing approach to human rights damages in England, which involves domestic courts mechanistically trying to replicate the European Court of Human Rights remedial practices, and there's an emphasis on trying there because it's very hard to discern what those practices are. Chapter 6 analyzes interest balancing approaches. Those are approaches where courts decide whether to reward damages and possibly quantum by weighing individual and public interests as they arise in that case. And then Chapter 7 looks at a number of other possible limiting devices, such as principles drawn from the EU law of state liability and US constitutional tort law, which is characterized by a myriad of official immunities. Okay.
Very good. Well, thank you, Jason, for that overview of damages and human rights, your new book. And now we'll have some comments from James Lee and Bryce Dixon. Jamie, do you want to kick it off?
Sure. Thank you very much, Jason, for that introduction, and congratulations on the book, which is a fantastic magnum opus. Bryce and I, in conferring, have divided the book up roughly in half, so I'm going to say a few things about the private law angle, and then Bryce will knows much more about public law than I do, so he will talk about that. I have 4 points that occurred to me while reading the private law bits of the book. The 4th is a Peter Burke's miscellany, so it's really 3 and several points. Firstly, the book is fascinating for anyone who knows the law of tort and a little bit about human rights, or who knows lots about human rights and a little bit about tort, or in your case both. One thing that I found myself wondering about a few times was the kind of getting stuck into the cases that you refer to. Now I'm conscious that there's only so much one can say in 500 pages, and also that you've published elsewhere on the topic, but particularly in chapter 2, you take issue with the probably leading Supreme Court decision to refer to vindication, which is Lumber. And I thought it might be helpful for the tape and for people in the room just to talk a little bit about that case and its companion, Combadzi. So in Lumber, the claimant, we'll call him the claimant, there's terminology. So there were 2 claimants, one Mr. Lumber and then one brilliantly called Mr. Mighty. So Mr. Lumber was a violent offender, Mr. Mighty was convicted of drugs offences, and they were both foreign national prisoners who were to be deported on completion of their sentence, but they were detained pending deportation, and the Home Secretary had a published policy about in what circumstances she would detain foreign national prisoners pending deportation. Both Mr. Lumber and Mr. Mighty were detained. However, it turned out that the Home Secretary had at the time practiced a secret policy that was to detain everybody, where possible, who was a foreign national prisoner, rather than this kind of careful case-by-case assessment. Now, the difficulty when this came to light was that it was accepted that Mr. Lumber would have been detained whatever, because he was a very violent, dangerous offender. Now, in the Supreme Court, in different combinations, split 6-3 on whether the fact that he would have been detained anyway was relevant to liability in false imprisonment, called the causation test. Does it matter that you can show, well, even if the Home Secretary had followed the published policy as opposed to pursuing him to the secret, detaining him pursuant to the illegal secret policy, he would have been detained anyway, so he's not lost anything, so he can't sue. The majority reject that argument, but a different majority say, but you're still only entitled to nominal damages because you would have been detained anyway. Whereas 3 of the justices, Lord Hope, Baroness Hale and Lord Walker, would have awarded a kind of damage that might be called vindicatory, and I know you take some issue with it. In the chapter, whilst knowing that you disagree with Lumber, I'm not quite sure whether you agree that that's in any way a problem at all, that set of facts, or whether it's just an intuitive quirk that we sort of think maybe there's something wrong, but you talk about the normative damage interference there, but then elsewhere in the book you talk about factual losses, and so I wonder whether it's a case that you think you should get a meaningful award to reflect the normative damage, but there will be some things, like if Mr. Lumber had tried to claim for loss of earnings, he wouldn't be able to, because factually he would have suffered that anyway. So just getting stuck into that kind of case, and particularly what the court should say. I know you have some terminological issues. Similarly, there's the case of Kambadzi, which was heard before Lumber, but decided afterwards, because 5 of the justices decided that case. Kambadzi, he was detained lawfully, but the review of his continuing detention wasn't always carried out in the way that it should be. So sometimes it was, sometimes it wasn't. Lord Brown in Kambadzi refers to an example he gave in Lumber, thinking of this situation, of saying, surely there can't be liability in false imprisonment, sort of 1 month on, 1 month off, yo-yoing, as Lord Brown says, between lawful and unlawful detention. That then feeds into a kind of general point you mentioned in your presentation about the seriousness and the extent of the interference with the right being the key question. And I'm not sure quite what that means in a context of a case like Lumber. Do you think it's a less serious interference? It's an interference nonetheless, but it's less serious than being detained when you shouldn't have been detained at all, or wouldn't have been detained at all? Or are you just asking, when you talk about the seriousness and the extent, the fact that you have been detained for 2 years without factual lawful justification, and how that feeds into these other questions of different kinds of loss? And then a final point on this issue of just whether nominal damages can ever perform the suitable role of recognising this normative damage. So, admittedly, Obiter in Murray and Ministry of Defence, Lord Griffith said that where you are detained unlawfully but you're unaware because you're unconscious or asleep, then you would normally only be expected to be awarded nominal damages, whereas I wondered whether your approach of looking at normative damage means that nominal damages should be exceptional, or they shouldn't be awarded at all. So that was my first point, just getting stuck into Lumber and some of the difficulties that it raises, because all 9 justices of the Supreme Court accepted that there was something funny or off, whether it was at liability or damages, about that point. Secondly, a few times you take issue with the terminology of vindication as it is in the cases, and that's quite bold, because one might think that it's helpful to you to refer to the cases that refer to vindication, but I know you take a different issue of the function versus damages. But particularly the Caribbean case law on vindicatory damages, so the Privy Council decision in Ramadan, the Privy Council has shied away more recently in Welch, for example, in saying whether this is really a different kind of damages, or it overlaps so much with exemplary damages that it doesn't gain anything. But I wonder whether the potential in that line of cases, even accepting that it may not apply in English law, subject to Lumber, whether it helps you or not, those line of cases, in feeding back into English tort law as sort of recognising the potential for vindication in, I think, your particular sense, but I'm not quite sure, so I'd be interested to know what you thought of that. The third kind of main point that I wondered about is whether there is a risk, particularly when you talk about how we can develop this approach in the context of human rights cases, of having cake and eating it, in the sense of saying we take the best bits of torts, damages, jurisprudence as it helps us understand in the case of human rights, but when it comes to adding heads of damage that wouldn't be recognised in tort, particularly in cases like the right to vote and so on, whether we can think of a different way to deal with that. And particularly because a couple of times in the book you refer to AIB Group and Mark Redlow, which is a trust case, looking at fusion of remoteness, for example, in claims for negligence versus claims for breach of trust. And you rightly say that in that case there was some dicta saying where it's a different kind of obligation, we need to think carefully about adopting the same approach. Coherence overall is helpful, but there's some scepticism. And I wonder whether there is, even though you identify throughout the commonalities and a shared content to the approach, whether there is something distinctive about a human rights claim relying, say, on my Article 5 right versus the common law right not to be false imprisoned or to freedom to roam or whatever we want to characterise that, whether there is a kind of meaningful difference, perhaps by analogy with the breach of trust point of those who argue that there's a distinctive custodial kind of obligation on a trustee. Could there be, where you're claiming against the public authority, a more meaningful content to that right that means we need to think a bit differently versus tort? Again, then just the miscellany, which are really just things that I found interesting that you observed. You talk about defamation on a few occasions. I wonder about the requirement in Section 1 of the Defamation Act of 2013 of that the claimant must show that the defamatory statement tends to cause or has caused serious harm to their reputation. I wonder whether you view that as changing the nature of the interest that is to be vindicated, or is it more connected to the nature of the loss that is shown? Does that mean that the function of the tort is now different, or is it just a shifting in what claimants have to prove, or the gravity of the defamatoriness? And then a couple of times you dismiss Chesterton, Afshar and Rees and Darlington, both cases which might be thought to be tending towards an approach that you have sympathy with of normative damage, but for negligence, which isn't a rights-based tort. I think you are convincing in your challenge to those theories. But I wonder whether there are observations in those cases about how tort works, or how causation is or isn't relevant in some contexts that could bolster your argument, whereas you tend to say that there are exceptions that prove the rule, whereas actually it might be more helpful. And then the final point really was just on Ashley and Chief Constable, where that's a case recognising vindication as a potential purpose, I think, rather than function of bringing a particular claim. So in that case, someone was killed by the police, naked while in his bed, but the police officer who shot him was acquitted in a criminal trial. The family wanted to sue. The police admitted liability in negligence for all damages, all losses flowing, even aggravated damages which may not be available for negligence. But the family wanted to pursue a claim in battery because they wanted a court finding that Mr. Ashley, well, there were actually three James Ashleys, father, son and grandson, and the middle, James Ashley, was killed. They wanted a finding that he had been killed unlawfully, the unlawful application of force. And you mentioned that a few times in the case, but of course two of the justices, Lord Carswell and Lord Carswell and Lord Newberger, were very sceptical about the appropriateness of vindication in this context as the sole motivation for a claim, given, and this is where I think it is an interesting study for your approach, that it wasn't just that there had been a criminal trial, it wasn't just that liability for all damage had been admitted, but there were also concerns about the courts being used for public inquiry kind of purposes in vindication. And so I wonder where you see that case fitting, given that it is using language of vindication which I think most of the time you seem to say that the courts are wrong in the way they use vindication, even if they are vindicating rights. So it was that final point of terminology that I wanted to add. But I took a lot from reading it, so thank you.
Thanks.
Thank you, Jamie. Bryce?
Right, thanks, Paul. It is a terrific book. I really did enjoy reading it. It's very scholarly. It's very thought-provoking. It's very well theorized and carefully argued, and it's very usefully comparative. I think you say yourself it's not fully comparative, but to the extent that it is, I think it's very helpful, and it's structured with almost a Cartesian logic. I think you're clearly a very structured thinker, and I'll come back to that at the end. The critique that you develop in chapters 2 and 3, basically arguing that damages for human rights violations should be treated as tortious damages, I'm happy to accept. I think you make a very strong case for that. I'm focusing in this brief talk on chapter 4 and your critique of the public-private divide, and I'm not sure why I'm doing this, and Peter is not. Well, why I'm doing it, and Peter is not doing it, because he's written explicitly about this, and you actually discuss his views in your chapter. I agree that the public-private law divide is an unnecessary one and possibly even a harmful one. I agree with your argument that it's not anchored in any sensible rationalisation within English law, and that referring to the public law, private law divide isn't helpful at all in the remedial field. Stressing the connection between public law and human rights law does, as you say, I think you say suppress or distort the distinctive nature of human rights law, and it possibly undermines the peculiar, separate, specific function which human rights law is meant to play. And more generally, I agree with your general dislike of talking about public law. You support, and I support, I think you support Michael Teichardt's approach, whereby he says governmental functions are all just socially constructed, and there's no sort of other theory behind it. I can't help but cite Peter's wonderful analogy that he makes when he describes public and private law as being a scrambled egg rather than a two-stranded rope. That sticks in my mind, and it's very valid. I think it's impossible to unscramble public and private law. I wondered why you stopped short of your critique. Well, I know why you did, because you don't have room in the book. There's already a lot in the book. I thought you might have mentioned global administrative law and then a critique of that as well, because I, for one, am still very, very dubious or sceptical about the whole concept, and despite Paul Craig's extremely valid efforts to persuade me to the contrary, I'm still unconvinced. And yes, I agree with you that Lord Wolf's approach based on public interest and the distinction between public law and private law, that if you followed his logic, then human rights law actually fits better into the private law sphere rather than the public law sphere, because it's actually protecting individuals' rights rather than putting pressure on public organisations to fulfil their duties. I think that's your take on it by and large. So all of that I agree with, and it's very well done in your book. You argue that human rights claims are private law claims, and more particularly they are tort claims. I would actually argue the converse in the sense that I think private law claims are basically human rights claims. And the only reason really why that reality, because I think it is a reality, is not reflected in the textbooks and the law reports is the historical one whereby the common law developed, let's not forget, through separate causes of action, primarily based on providing a remedy for a very particular kind of wrong, so an action for money had and received, an action on a debt, etc. And even in the public law sphere, you yourself referred there to the prerogative writs, which were looking for a particular remedy, the certiorari or mandamus, etc. They are the foundation for the development of administrative law as we know it today. Insofar as you can draw a connection between all the different common law causes of action, I think you might refer to the liberty principle, the idea that everybody is free to do everything unless there is a particular legal prohibition, whether it derives from Parliament or from judge-made law, not against doing it. And I was at a conference in London last week on the right to vote and the whole refusal of the British Parliament and government to implement the Hart decision in the European Court of Human Rights. And Geoffrey Giles made a very impassioned defence of the common law's ability to protect rights, and he relied on the notion of the principle of the right to liberty. And that's a concept that Dicey himself reinforced in his introduction to the study of the law of the Constitution, when he was emphasising parliamentary sovereignty and distinguishing the English approach from the continental approach of droit administratif, which itself was a product of post-revolutionary France and not a throwback to Roman law as the Code Napoleon is. And let's not forget that the Code Napoleon prohibits judges from making law. But I think it's becoming apparent that common law causes of action, be they in tort or a contract, and even the common law of crime. You yourself say in your book, I think, that David Feldman includes criminal law in his concept of public law. It's quite part of his big book on public law, and I think that's right. But I think these common law actions and remedies are linked by the fact that they protect basic rights, human rights. So the criminal law protects people's liberty, freedom, their physical freedom, their moral, intellectual freedom. But the common law has not owned up to that. So the common law has been protecting human rights, but not consciously, or not shouting it from the rooftops. And it's really only since the Human Rights Act came into force in 2000 in the UK that judges have been developing a common law of human rights. There was no such thing as human rights law before 2000 in the eyes of the common law. That realisation hasn't worked its way through the law of torts as yet, so we don't get judges describing the law of torts, the law of false imprisonment, or the law of interference with goods, etc., as protecting the right to liberty or the right to peaceful enjoyment of one's possessions. We don't see the law of trespass to the person talked about in terms of the right of somebody not to be ill-treated or to have their security infringed, etc., etc. And likewise, criminal law, insofar as it's developed on the basis of common law ideas, so the law of murder, for example, is very strangely never discussed in terms of the right to life of the victim. But yet, obviously, that is the purpose, underlying purpose, as I see it, of the law on murder, is to protect people against losing their life. And let's not forget as well that criminal law as developed by the common law is hugely based on what is now called the right to a fair trial. I don't think common law judges have used that phrase until very recently. They have talked about rules of natural justice, they've talked about abuse of process, etc. in the context of criminal law, but it's only very recently that they've talked about a right to a fair trial, because that's the way it's put in the European Convention of Human Rights. So all along, I think common law judges have, like Monsieur Jourdain, they've been in the Bourgeois, they've been talking prose and not realised it. They've been talking human rights language, but not realising it. And they are now waking up to the reality that what they're doing is protecting human rights, but they need to do it more schematically. And I think even commercial law may soon have to concede that it's partly built around the protection of human rights, because we're beginning to see a reaction against the freedom of contract idea. We're beginning to see the interests of all contracting parties, not just consumers, being weighed up against the interests of the other party, I wouldn't be surprised if in due course the common law judges start inserting human rights thinking into contract law. Now, coming to the actual point about damages and whether they should be damages for breach of human rights should be treated as tort damages. My starting point for damages in general, remedies in general, is that when a person goes to court claiming that something is illegal, they first and foremost want and deserve a declaration that the piece of conduct in question was unlawful. That is the starting point in all cases and always has been. And together with the reimbursement of their costs for having to seek that declaration, I think that's all they initially deserve. If they can then prove other pecuniary losses and sometimes non-pecuniary losses, then I think they do deserve to have those compensated for as well. But in human rights cases, for the time being at least, and in the context of the UK at the moment, I'd be wary about extending the law of damages in the way that you suggest, because, as I'm sure you all know around the table, the concept of human rights is not a terrifically popular one in the UK at the moment, not just with the government or with the majority of parliamentarians, but also with the people. And that's because we have come late to the idea of human rights, and we've derived it from Europe, either the Council of Europe or the European Union. At least in Canada, you've developed your own homegrown idea of rights. You own it, you're proud of it, in a way that I think the UK is not proud of its Human Rights Act. Even Tony Blair, I think, is no longer proud of the Human Rights Act. So now is not the time to start giving victims of human rights abuses very large awards in the courts in Britain, because that is going to damage the concept of human rights even more than it has already been damaged. And I know that that's unprincipled in a sense, but it's facing the political reality, and this is where I come back perhaps to the initial point that your Cartesian logic is extremely appealing and attractive, but I think sometimes it needs to yield to the political reality and to Oliver Wendell Holmes' phrase about the life of the law not being logic but being experience. A couple of afterthoughts. If you are to pursue your logic, then it seems to me that human rights law will need to be operated at the horizontal level and not just at the vertical level. You're basically arguing, aren't you, that people should be able to bring human rights claims against other private parties, and that somehow tort law and human rights law should merge. Maybe you're not.
I don't explicitly make that claim.
No, but I think there's a certain logic in that direction. Yeah, I think I'm going to stop there actually. I've talked enough. So, very good book. Very well researched. Congratulations on producing the book.
Thanks very much.
Well, thank you all for those interventions, for Jason's overview and the comments. I think it might be fun if now the rest of the audience had a chance to give their 2 cents or pose any questions that they have. Is there anyone who wants to add something to Jason's already long list? But you know,
it's been published. It's non-minutes, right? so our list can be as long as we like, right, Jason?
Well, you know, there's always the sequel, right? That's
Volume 2, right? The second edition.
Response to critics.
Sandy.
Oh yes.
So it sounds like a really impressive book, and I'm looking forward to reading it. I just have a question about the distinction between the vindicatory and and approaches to damages which aren't vindicatory. So you seem to draw to say there are two features of the distinction in what you said there. One of them is that a vindicatory approach typically applies to more fundamental interests than non-vindicatory, a non-vindicatory approach to damages. And I just wonder what the motivation for thinking that, say, my being touched without my consent is more fundamental in some way than my leg being broken or chopped off. That's one question. The second feature of the distinction was that you said that in torts to which the vindicatory approach applies, you get damages for the interference itself. And so I was just wondering, you know, in negligence, aren't there some cases where, I don't just mean the ones like Chester and Ash are in the case like this, but aren't there cases where you are getting something like an award just for an interference with your knowledge of interest? So if you negligently damage a book, which is my seller that I'm never going to read again, that's pretty worthless, wouldn't I get some? I would get some sort of damages for that in the tort of negligence. Even in a sense, isn't that somehow protecting my normative interest in the possession or use of my book? So those were my questions about vindicatory knowledge.
Okay. So
yeah, you could reply to Sandy, and I guess you can maybe start replying to Jamie and Bryce. You don't have to reply to them all in one go.
So I think that's a question that's come up a few times. But I addressed this, I think, in chapter 2, and that I don't say that negligence doesn't protect important interests, but I think it protects them to the extent that you suffer loss through interference with them, right? And that's the distinction. So various features of the negligence action, such as in particular that loss and material loss in particular, is the gist of the action has to be proven, mean that it's difficult to argue that negligence is concerned with interferences in itself and protecting important interests in and of themselves. So think of the Rothwell case, where there was clearly some interference with someone's physical integrity, but that wasn't said to constitute a material loss, and therefore no action could lie. So I think, as Peter has said in his Anatomy of Tort book, some interests are protected in and of themselves by certain actions. In other contexts, interests may be protected only to the extent that you suffer harm through interference with them. So I think protection and to an extent vindication are functions of the law of negligence, but I don't think, if you consider its significant features, that those are the primary functions of that tort, in the same way that they are the primary functions of torts like trespassory torts, where loss is not a prerequisite, for example, and but for causation is not an element of the action as well. So that was one point. Your second point was on damages and negligence. So as Jamie said, I do mention Chester and Rees and those types of cases. Certain rights theorists tend to pounce on them as emblematic of the general approach to damages and negligence. So I think part of my saying that they are exceptional is a response to those theorists. I think it would help my argument if I could say a vindicatory approach would take into damages across all of torts, because then I could say all of tort is concerned with that rather than this narrow band of actions. And in particular, it would help me to justify, although I think I still justify it, that you should be able to get vindicatory damages for breaches of positive duties in human rights law, which tend to resemble negligence a bit more than negative human rights obligations. So I think if I'm being honest, I think those types of cases are exceptional, even though it would help my argument to say that they're not. In the case of the book, I think if you lost nothing of value, you wouldn't have a claim. So you must have lost something of value, even though it was a sort of a book that had fallen into desuetude and you weren't reading it anymore. But if you couldn't show that it was of material value, then I think it would be hard to get an action off the ground. But also, it may just be considered de minimis loss in any case, in that example, I think.
Can I just make one quick
Sure.
response? But what would you say to cases like the sort of famous hypothetical where someone breaks someone's leg when they're on the way to an airport, and they would, when they got on the plane would have been blown up through a natural event, and so the torts made them much better off. So someone's negligently broken their leg, but the torts made them materially much better off, incontestably so, because they would have died otherwise, and let's assume their life was worth living. It seems very likely you'd have an action in negligence there, and on the basis that you've suffered damage, and damage I don't think is the same thing as loss. So to say that the action, the gist of a negligence claim is damage, and damage isn't quite the same thing as being, I know Hoffman says this in Rothwell, but he's just wrong. This is being filmed, isn't it?
Yeah. You can strike that from
with
the record.
respect. He's retired, it's fine. So I just think, would you say that there would be an action in a case like that?
Well, I think there are cases, I can't remember the name of the case now, but it's mentioned in the book where someone is negligently not given safety equipment by their employer, and they would have, and they're injured, but they would have been injured anyway because they wouldn't have worn the safety equipment, and in that case there's no action.
Yeah.
So
there's no damage in that case.
Yeah, there's no damage in
which
that
is
case.
causally connected with the negligence.
Okay.
There is causally connected in my case.
So just explain that, the distinction between the case a little more.
So if I fail to provide a safety harness to someone and they wouldn't have worn the safety harness anyway, they've suffered something negative has happened to them, but there's no causal connection between the defendant's negligence and that negative event, because if I fail to provide the harness and they wouldn't have used it anyway, I think you'd say there's no causal connection there at all. But in the case with the driver, it's incontestable there's a causal connection between the negligence and the broken leg. So they've suffered, I think some people would say, so Donal Nolan's got a piece saying that they would suffer damage in this case, but they wouldn't suffer any loss because the torts made them much better off than they would otherwise have been. So they suffer damage at the points of some physical event which has made them in some way, relative to some world, more worse off in some way. And it seems like they would have claim of negligence in that situation. I mean, maybe the answer is just...
I suppose it depends to what extent you take it, how far, in terms of timeline. I mean, you know much more about causation than I do, but in terms of timeline, what events you consider salient to the but-for inquiry in negligence, because the plain event may take place some distance in terms of proximity from the event where the person broke their leg. But I think it may well be it obviously is a hard case, that's why you've raised it. But I think in general, the fact that you have a but-for requirement in negligence reflects that it's a loss-oriented tort, right? Otherwise you wouldn't have that requirement. You'd just say, well, if someone interferes with your interests negligently, that's the action, right? You wouldn't need to engage in a but-for analysis. Okay.
Is there anything more in what Jamie and Bryce said that you wanted to?
There were a few things.
The trailer for the sequel.
So on lumber, I mean, I discussed that at reasonable length in chapter 2, and then vindicatory damages at length in chapter 3. I think the Supreme Court, so this was the case where someone suffered a false imprisonment, but if the government had acted lawfully, then the person would have been imprisoned anyway. So the argument is intuitively there's no loss there because they would have been in jail, even if the government had not acted unlawfully. I think in this case the Supreme Court, which is increasingly not fond of referring to precedent, mislaid the long-standing approach to damages for false imprisonment. So in the book I explained that if you suffer a false imprisonment, ipso facto you suffer an interference with your interest in liberty which you ought not to have suffered, and therefore you get damages for the interference in of itself. And the rationale for that is that the common law, a bit like Bryce's liberty principle, very similar in fact, the common law assumes you in your natural state to be free, right? If someone comes along and interferes with your liberty, that's an unlawful interference, a wrongful interference with your liberty, unless they can show otherwise. If they can't show otherwise, then the common law assumes you should have been in your natural state, which is that you should have been free. So the counterfactual analysis is never implicated, at least as far as normative damage is concerned. In terms of consequential losses, given the nature of those losses and how they're distinct from normative damage, I think it would implicate a counterfactual analysis. But I think even on a counterfactual analysis, you could still say the Lumber decision is wrong, because the counterfactual analysis pivots on what the wrong is, right? And there are different ways to conceptualize the wrong. So if you say the wrong is interfering with someone's liberty, then you would ask, well, but for the interference of liberty, what position would that person have been in? Well, if there was no interference with their liberty, they would have been free. Right? Whereas if you conceptualize the wrong as also including defenses, you would ask, well, but for the unjustified interference with liberty, what position would the person have been in? Well, in the counterfactual, they would have been justifiably deprived of their liberty. So in that case, there would be no loss on a material loss analysis. I think there are good reasons. I don't think there should be counterfactual analysis in terms of normative damage at all. But if there is, I think there are good reasons for preferring conceptualization of the wrong more narrowly as an interference of liberty, in which case, even on a counterfactual analysis, there would be loss in Lumber. And I think those reasons include that it affords greater protection to liberty, and which is what the gist of false imprisonment is. But secondly, in terms of the structure of the law, why should I have to offer a defense for my actions as a defendant if I've not done anything wrong? So it's very hard to justify requiring the defendant to offer a justification for their conduct if you can't initially say they've done something wrong. So the wrong is they interfered with your liberty, therefore that's a wrong, and therefore they must justify it.
But just
Jamie has
on that,
10 seconds for
just on the seriousness of the interference and the nature of normative damage and so on,
Yeah.
if we contrast Lumber, or perhaps Kabadzi, with a situation where, let's say I was imprisoned for stealing a loaf of bread, and no one got hurt.
Yeah.
So if the Home Secretary had applied the lawful policy, the published policy, I would not have been jailed pending my deportation. If you compare that with Mr. Lumber, do I get exactly the same amount for my normative damage? Is there a qualitative difference in the extent of the interference and so on?
So the normative damages would be assessed according to certain criteria. So if you're in prison for a longer time in a more confined space, you're going to get higher damages compared to if you're in prison for a very brief time in a large warehouse, right?
But
so that's one.
That's
one. Yeah. So and then the second point is, in the Lumber case, you'd only get damages for loss of liberty. You wouldn't get damages for consequential loss, like the distress you suffered through being imprisoned, right? Whereas in your example, where the person, it's very clear that the person would have been free on a counterfactual analysis, you get normative damage plus consequential losses.
But the normative damage would be equal in two scenarios.
Well, it would depend.
It's the same award.
It depends on if the length of imprisonment was the same.
Identical cases.
Okay, ceteris paribus, normative damage would be the same. because it's not linked to the peculiarities of the individual's subjective experiences through their suffering of the wrong. Okay, now, I might just take one of Bryce's points out of the principle of equal treatment.
Or else do you?
So I think this point about the unpopularity of human rights in the UK and the unreality or the fact that it would be unpopular if courts started to award significant amounts is a point that has been made to me. I suppose my task in the book is, given that we have this remedy, what is the approach that ought to be taken as a matter of legal principle? I take your point about the unpopular, this being unpopular. In chapter 6, I say that government and parliament are perfectly able to respond if they feel that public interests are being compromised by the more liberal award of human rights damages. And I have a number of case studies to show that they are far from apathetic and far from lacking in capacity to respond where they think liability has gotten out of control. I suppose the courts in the UK, and in particular in Anna Frieva, Lord Wolfe did take this point into account, and he said, well, if we give significant damages to asylum seekers, it's going to bring the human rights sector into disrepute and not be popular. I think there are serious problems with courts taking that sort of factor into account, and that it completely undermines one of the purposes of human rights law, which is to protect minority groups and vulnerable groups who may be.
You need the rights, popular people or
that's
unpopular
right,
people.
But you may not be saying that courts should take that into account on an ad hoc basis. You're just saying there's a need for moderation, lest human rights law become even more unpopular.
At the moment, yeah.
Yeah, that's right.
But also under Section 8 of the Human Rights Act, Parliament has already sent a message to the judges saying, you know, okay, I agree with you, they're wrong to tie it to the mirror principle, they're wrong to say, only do what Strasbourg would have done.
Yes.
They're sending out a clear message saying, unless you've already got some jurisdiction to give damages, to take one example, you can't award damages.
What do you mean, unless you have
tribunals can't award damages
Sure,
for breaches
okay.
of human rights.
Okay, that's a very minor limit, isn't it, in terms of a court's ability to award damages?
Well, I'm just using it as an example
okay.
of one of the limits which Section 8 imposes already
Yes.
on judges.
Okay, so there are some limits in Section 8, so I have a detailed analysis of those provisions at certain points in the book. I won't go into it now because it's somewhat, it could be somewhat not the most exciting aspect of the book, but nonetheless necessary. But I think I do have something in the book on the move to enact a British Bill of Rights to replace a Human Rights Act, which one of the central motivations seems to be that, as you say, Cameron and co. don't like the fact that human rights law is influenced by Europe. And I think a key message that they keep stating is that a British Bill of Rights would break this link with Europe. I think that's important because if you have a British Bill of Rights, I think the argument for a tort-based approach is all the stronger, and maybe it will be viewed as more legitimate because it's a homegrown approach. And they mention, I think I say it in the book, in their pre-election policy document, their manifesto, they say that the common law has this tradition of awarding remedies in response to concrete factual circumstances rather than in response to interferences with abstractions, which is almost a quote from Dicey, right? And I think that raises the further point that tort claims in the common law tradition have been, as you said in your comments, the principal means for protecting basic rights, and those were considered to be rights and tort were considered to be constitutional in nature from Blackstone to Dicey, and continue to perform a very important function in affording strong protection to rights. So it would be drawing on that tradition, I think, if you were to award damages under a British Bill of Rights, and maybe it would be more popular because it was British. I'm not sure.
Any other questions, Matt?
Yeah.
Well, no. Remember, I haven't read it. So So you may be able to dispose of my objection or question.
I'm surprised you haven't got around to it yet.
Well, yeah. How far or against whom is this remedy to extend? In other words, we might obviously you would say it extends to government, but are you suggesting that the remedy extends to private individuals as well?
I don't enter that debate in the book because, as has been pointed out, it's not a pamphlet. It's a serious tome.
You wouldn't want to drop it on your foot.
That's right. There wasn't much more space for addressing horizontal effect as well. I mean, the argument I make is about damages claims against public authorities as defined under the Human Rights Act, which would include entities which we might consider to be private in nature. So, for example, where a service is contracted out, like a private prison, that authority may be liable to be sued under the Human Rights Act. I don't extend the claim to private individuals, but I can see, I've thought about it, and I do think it is hard to argue that if these are the most basic and fundamental of rights, that they should be capable, they should be liable to be interfered with by private actors at will, but not public actors. And that really goes to the critique of public and private power in the book, that it's very difficult to differentiate the two. And there are significant nodes of power in what we would consider to be the private realm, which may be more powerful often than public authorities.
Right. I guess when you go down that road,
yeah.
I think you have to contend with the North American trend that human rights generally seems to me to be state action as opposed to private action. We seem to have a much clearer distinction. I mean, the BC, the British Columbia Court of Appeal just this past week held that a provincial university, is not liable for violating free speech on its campus. Mm-hmm. So it is not sufficiently governmental. Mm-hmm. And so if universities can, I certainly can violate Floridians' rights. So mm-hmm. we're rather pretty particular on that.
That's right, but I mean, if you look at the law of tort, the most basic interests have been protected among private individuals for a long time. It may be that that's a more limited list of protected interests because it reflects an older age and what was important to 19th century judges. And if we were to revise the law of torts now, we would include breaches of privacy, as is increasingly the case, including in this country, breaches of freedom of expression, etc. And there are, as Bryce said, really interesting developments in private law and in public law, which show a real breakdown of the divide. So, for example, and I'll just mention it briefly, the UK Supreme Court last year decided the case of Braganza, where the court explicitly read across the common law principles of judicial review to govern exercises of discretions under contracts between private parties on the basis that there was a similar concern for the regulation of abuse of power in that context as there is in the common law of review. They apply Wensbury directly in that context among private parties, one of which is BP. So there are interesting emergent developments which suggest that the law is slowly catching up with the breakdown of the public and private spheres in social, economic, etc. life.
I'm mindful that the clock is moving on and we have a restaurant reservation. But we might have time for one more question if anyone is...
Can I make an observation just in the back of what Jason has just said? It's odd, isn't it, that certainly in the UK, and it may be the case in Canada as well, private entities can be sued for discriminating against people. They're bound by the law on equality, but they're not bound by the law on human rights. And that seems to me to be illogical. And I know that's a statutory thing. Well, I think you describe the Human Rights Act as not creating a statutory tort. I don't know why you say that. In the introduction, I explained that I want to avoid questions such as
is this a tort? Is this a public law action? Is this a private law action? Simply because there's no set meaning for those terms. So I argue for a tort-based approach, but not on the basis that I consider the claim under the Human Rights Act to be a tort, but because I think it performs similar functions to certain other actions, which happen to be in the law of torts. I think people can get distracted by these types of difficult line drawing and categorization.
Do you think breach of statutory duty is a tort?
Well, I think it's classified as a tort, but I'm not sure how much weight you can apportion to that classification. Because as I say in chapter 2, I think different actions within the law of torts perform different functions, and you can see that from the fact they have radically different structures. So I'd look at each tort individually and ask what is this tort trying to achieve.
But it's a civil wrong.
Yeah, I think that's an interesting question. So I think I would say that all torts involve breaches of private rights, and in that sense are civil wrongs.
Is a claim
how
under
much? Sorry.
Is a claim under Section 7(8) of the Human Rights Act?
Yeah.
It's a civil wrong, so you can shed the concern about tort and.
Yeah. Well, again, I don't see civil wrong as carrying that much explanatory power, but I would say, and I argue in Chapter 4, in an extended discussion, which people of Hofeld will dislike very much, that rights under the Human Rights Act are individual Hofeldian claim rights. They are genuine rights, so when they're breached, there is a personal individual wrong compared to duties in the common law of review, which I think are public duties owed to the public as a whole, so that when they're breached, there's a public wrong. But in each case, I think the nature of the obligation reflects what the fundamental aims of the area of law are. Right? So in human rights law, we're trying to protect individual interests. There's no surprise that the nature of the obligations are individualized duties, whereas in common law review, I think that the law is trying to protect public interests, and the nature of the wrong in that context reflects that those normative concerns. Okay.
All right, I think we can leave it there. Thanks very much, Jason. Thanks to Jamie and Bryce for agreeing to comment. Thanks a lot.
Thank you.